Welcome to today's program titled Time Well Spent, 10 Years of Wage and Hour Wisdom and What's on the Way. At this time, all participants are in listen-only mode. For those of you who are logged into the web presentation, you are encouraged to submit questions throughout the conference by typing them into the Q&A box on the right-hand side of your screen. For those interested in obtaining CLE credit for this webinar, an attendance verification code will be read during the presentation that will be required on the CLE attendance affirmation form. Please write this code down as it will not be reread and it is required for CLE credit. Copies of the webinar recording and materials, along with the CLE attendance form, will be distributed to attendees in the days following the webinar. On the next slide, you will see a legal disclaimer. This presentation has been prepared by Seyfarth Shaw LLP for informational purposes only. The material discussed during this webinar should not be construed as legal advice or a legal opinion on any specific facts or circumstances. The content is intended for general information purposes only, and you are urged to consult a lawyer concerning your own situation and any specific legal questions you may have. At this time, I would like to turn it over to our first speaker for today's program, Noah Finkel. Noah, please go ahead.
Hello, everyone. I'm Noah Finkel from Seyfarth Shaw in Chicago, along with my partners Andrew Paley and Brett Bartlett from Los Angeles and Atlanta, respectively. We are three of the co-chairs of Seyfarth's National Wage Hour Litigation Practice Group. We're also three of the authors on the spine of, as you'll see on the next slide, our treatise, Wage and Hour Collective and Class Litigation, which we published now more than 10 years ago, which is hard to believe. This process started as a white paper that we updated from time to time, and eventually we thought, hey, this is getting really thick. It could be a book. So we went big and went all the way. For those of you who have subscribed to it and have the hard and electronic copies, you know that it provides thick chapters on everything ranging from the beginning of a wage hour lawsuit and conditional and class certification, all the way through defensive tactics through trial, and covers about a dozen substantive wage hour issues as well. And Don, if we can go to the next slide, please. We did, it's a thick book. Andrew, Brett, and I did not write all that text. We had tremendous help from our practice group, who shouldered most of the load. That practice group is made up of about 100 lawyers who devote a substantial part of their practice to defending wage and hour litigation. And that's the group that primarily wrote this under our guidance and that of our then practice group leader, Richard Alfred. If we can go on to the next slide. We now update that twice a year, and for that we'd like to provide special thanks to Kelly Kolker, who's a member of our group, and she's the one who prepares all the updates and keeps this up to date. Other team members help her a lot with that, as does Amy Abate, our practice development manager. We'd also like to thank our publisher, American Lawyer Media and Law Journal Press. And now that this book has been out for 10 years, we thought it's a good time to catch up on where we've been and where we might be going. So today, you can see the agenda on our next our next slide. We're going to do a brief overview of the wage and hour litigation landscape, and then each of us are going to do some top 10 lists of what we've seen in the last decade from a national litigation perspective, a compliance perspective, and from a California perspective. And then we're going to talk about what we think is going to be coming up in the next 10 years. So with that, I'd like to turn it over to Brett.
Great. If you go to the next slide, please. So the wage and hour landscape, we're looking in retrospect and considering what's happened in the past 10 years. It used to be, when we looked at a chart showing the number of FLSA filings nationwide, it was almost always consistently upward bound. In the past 10 years, we've seen some variability across the years with the numbers of filings spiking, as you can see, in 2015, and then kind of diminishing. And you can notice the lowest number of cases filed and guess why that probably was in 2021. On the tail end of the pandemic, or maybe right in the midst of it, depending upon how you look at it. It is interesting to consider whether COVID actually played a role in creating an environment and a landscape that would be a genesis of more actions to come. And it's also interesting to consider whether those inflated numbers back in 2015 and around then arose because of the decertification of collective actions or the willingness of plaintiffs' counsel, well-heeled plaintiffs' counsel, to file individual suits after not succeeding in winning conditional certification or authorization to send notice out. But it is interesting to see the landscape as we look backwards. If you go to the next slide, please. It used to be as well that I would, anytime I thought about where the most cases have been filed, think immediately thinking of the FLSA of Florida, because the trend in FLSA litigation, although it likely began in California in the early 2000s with the state court filings then, and then motivating some additional FLSA actions, we really saw a huge spike in Florida as the decades wore on into the 20s. But if you look at this chart, you'll see that by a large gap, the most cases are filed in New York in the Eastern District and Southern District. And it may be that the reason for that is that New York has a 6-year statute of limitations under state law and provides for Rule 23 class relief under that state law. And so we see a lot of hybrid actions being filed. But you can see that the Southern District of Florida and Middle District of Florida are still kind of keeping pace pretty high relative to the rest of the jurisdictions. Other places are interesting, I think, and worth considering. That Arkansas only has about 64 cases, but there's been a lot of activity in the Eastern District and across the state. If you'll go to the next slide, please. And here's a heat map, and especially for multi-unit, multi-state operators on the call, this is interesting, I think, and it's worth paying attention to when you get the materials in follow-up to our presentation. This heat map shows where the most activity is with FLSA litigation. It doesn't take into account the state court actions or the state court only actions that land in state court. But you can kind of see there a map of where we are seeing the most activity. Again, Florida and New York are the highest numbers, but those slightly lighter orange states are also places where we have seen, and this is again by 2022 numbers and not 2023 yet. But if we go to the next slide and consider the industries that are impacted, you know, we were talking about this among the three of us, and I was curious, again, based on 2022 numbers, to see which industries were facing the most hits. And really, the answer is all of them. And it depends on how you describe the industry, obviously. But these are the places where we saw most of the actions filed. And it's a widespread across all industries. And I think that goes to a theme that we'll see, that much of the activity that we see really is motivated by the creativity and increasing innovation of plaintiffs' lawyers in the wage hour bar as they consider new industries and new types of suits to pursue. Next slide, please. So it just so you can kind of see the topography of what we saw in 2022. And this is informative only probably for some of the stats geeks out there on the call, but we saw kind of a balancing number of cases filed from month to month and petering out kind of towards the end of the year. But if we go to the next slide and take a look at what's happened in 2023 so far, we've had 3,613 cases filed in the year so far through the end of July. And really, if we're tracking on average per month, which might not be the way to do it, given what we saw in 2022 with cases kind of trending off at the end of the year, but if we stay with the averages, we'll have another year that's around 6,300 to 6,500 cases having been filed. And so really, this trend is not going away, and we may see increases for reasons that we talk about in a minute. But even more interesting than some of this sometimes is California. So next slide, Andrew, you want to mention California?
Sure. So California is an interesting microcosm for all sorts of reasons, but in the wage and hour space, it's no surprise that oftentimes what starts in California heads out to the rest of the country. And so even if you don't have employees in California, it's important to keep an eye on what's going on out here because for better or worse, we tend to be the bellwether in terms of what happens. Historically, California started with the wave of exemption misclassification cases, hit retail industry, finance industry pretty hard in terms of the managerial and administrative exemptions. But that's morphed over time, and we see far less of that and many more different types of claims that we're going to get into in a little bit. But in terms of the volume of claims, out here we have been somewhat immune to the cycle that Brett had been mentioning, and what we're seeing is an ever increasing trend of litigation. Each year it gets more and more. Now there was a dip during the initial period of COVID when the courts were closed because of lockdown, but that came roaring back. And so what we're seeing over the last 10 years is an ever increasing volume and diversity of cases. Currently, we are looking at something on the order of 20 to 25 new cases filed each day, every day. That's a mix of both class actions and PAGA cases, Private Attorney General Act cases, for the people that aren't familiar with that. With the PAGA cases lately over the last couple of years, actually surpassing the number of class actions being filed. And in large measure, we can tie that to the increased use of arbitration agreements by employers with class action waivers, which has diminished the number of class filings. Unfortunately, and we will be talking about this a little bit more, despite the recent U.S. Supreme Court ruling in Viking River, the California Supreme Court in the Adolph versus Uber case has given a shot in the arm to plaintiffs' counsel with regard to the PAGA filings, and so we expect those are going to keep coming back with vengeance, but I will turn it back over at this point.
Now what we want to get into a little bit is our top 10 list that we provided for the last 10 years. And we're going to start on this next slide with the top developments from the decade and what we've seen. First, we want to level set though. 10 years ago, what were we dealing with? Some of the issues have obviously been the same. We still have classification claims, off the clock claims, but the flavors of those were different. We wondered about whether pharmaceutical sales reps were exempt, and the Supreme Court had just resolved that yes, they're outside sales. Supreme Court also was looking at whether security checks constituted compensable time under the FLSA. That was a hot issue coming, and we saw that decision slightly a little bit later. Then the regular rate was never really an issue that many thought about. We thought that maybe the Walmart versus Dukes decision would chill collective action certification a little bit, since the Supreme Court had sent signals that that mass litigation in the discrimination context ought not be readily pursued. We thought maybe courts would get the message and apply that to wage hour litigation. Unfortunately, they largely didn't, as we'll see in a little bit. We really wondered, hey, could employers put in arbitration agreements that have class waivers and make that work? We have our doubts about that. 10 years later, that's pretty well settled. We just in 2012 seen the Brinker decision say that meal and rest periods just had to be provided and didn't have to be insured, and we wondered, will this be the end of meal period litigation? Far from it. And we didn't really give much thought to PAGA claims. They weren't very prevalent, and they sure are now. So let's now go to the next slide, please. Now, I've got up here the top 10 developments that we've seen from the last 10 years at the national level. So this excludes things that are unique to California. And I'm not going to talk about all 10 of these because we're just not going to have time. But I'll keep this slide up for a little while I highlight really the first of these 5 developments, which all show really kind of like the push and pull of collective and class litigation that we've seen a little bit. So remember, in 2012, we had been seeing a huge spike from the last 10 years in wage and hour class and collective action filings. That graphic Brett had up earlier that was fairly static with ups and downs, it was just going up. Now, some of that was due to loose, easy-to-meet certification standards. We were hopeful 10 years ago that Walmart versus Dukes would put somewhat of a stop to that, but it hasn't done that. Courts generally have not been applying its reasoning to collective actions, and with some notable exceptions, have continued to make collective action certification, particularly at the notice stage, pretty easy for plaintiffs. In fact, we've been also seeing greater use by the plaintiff's bar of the class action mechanism available under state wage hour law, and that's been significant in a couple ways. First of all, the class action mechanism that's available for state law claims and not federal law claims is opt-out rather than opt-in, so you get a lot more participation from current and former employees under class actions than you do under collective actions. Second, there are some nuanced differences in exemptions and the definitions of hours worked that can be traps for the unwary. And third, there are different remedies. For example, New York has long had a 6-year limitations period that Brett mentioned earlier, but some state laws are getting pretty nasty. Massachusetts has treble damages. Illinois, and this is a pretty recent amendment to its statute, has 2 sources of kind of remedies or penalties. One of them is it increased its interest penalties from 2% per month to 5% per month, which is 60% per year, in annual interest. And it has treble damages on top of that as well. And because of this, and this has really been, we think, the biggest development of the last 10 years on the litigation side, is that employers gradually have adopted mandatory arbitration programs with collective and class action waivers. Now, it was not clear 10 years ago that this would work. There were many arguments about whether mandatory arbitration was permissible and whether a class waiver would be considered void. Now, unfortunately for employers, the U.S. Supreme Court has ruled in companies' favor in several rulings that have cleared the way for the use of mandatory arbitration program as a class action avoidance tool, and employers are using that tool more and more. In fact, it's now to the point where those who don't have arbitration agreements are kind of a target for plaintiffs' lawyers. Meanwhile, we've seen the plaintiffs' bar fight back. Andrew's going to talk about how they're using PAGA in California to limit the impact of class waivers. But in addition to that, we've seen the plaintiffs' bar get quite creative and aggressive in how they're able to obtain a real massive client, even without FLSA collective action notice. They're using social media to find claimants by the tens, hundreds, or sometimes even thousands. And they're filing those claims all at once. So sometimes you get a collective action that will have a case caption that goes on for pages because of all the people they've already collected. And then as the companies that maintain arbitration programs, they're having those claimants threaten to file arbitration demands in mass. So the company has to defend hundreds or thousands of similar arbitrations, and more significantly, perhaps, bear the few $1,000s in immediately due administrative fees for each of them. And then meanwhile, we do have some good news. Just in the last 2 years, we've finally seen some courts recognize that collective action conditional certification has been getting out of hand. And both the Fifth and Sixth Circuits, with Sixth Circuit decision being just a few months ago, they've heightened the standard that plaintiffs need to meet for their ability to send notice to a putative collective or obtain conditional certification. And that's a trend that we hope is going to spread. With that, I want to turn that over back to Brett to talk about what we've seen in the last 10 years from a compliance standpoint.
Great, thanks, Noah. And if you'll go to the next slide, you'll see that I also have a list of top 10, but these are not in priority order, and it's not an exhaustive list, quite obviously. But I always think about the question of whether we see more litigation because of an absence of compliance, or if litigation is what drives efforts to comply with the law, or if we see just litigation and updates to compliance practices based on the environment. And so I think they really all kind of drive each other. They're all connected. And why are we continuing to see so many lawsuits under the FLSA and under state wage and hour laws, and frankly, local ordinances? Like, for example, in Philadelphia, there's a predictive scheduling ordinance called the Fair Work Week law that is giving rise to class actions under that ordinance, and question whether ultimately that ordinance will be upheld by courts, because there are some questions about whether it was validly enacted. But paying attention to the various states' laws and local ordinances really is important, because we're seeing actions pursued under almost any of them by ever more creative plaintiffs' lawyers. But if you look at the list that we've got here, I think kind of about the environment and things that have arisen out of claims being made because of that environment. There's so much of it within the past 10 years that's really come to the head because of the pandemic. And so I think about if I look at 1, 2, and 3, as well as 5 and 9 especially, I consider that those are somewhat environmental, as we've begun to consider from a compliance perspective, how do we deal with remote work issues? Non-exempt employees who are working at home, making sure that we're keeping account of the time that they work before their shift starts, if they're working at all. How do you capture that? How do you ensure that they're taking their meal breaks, not working during their meal breaks? How do you capture work that's at the end of the day when they might be doing things that are technically beyond their shift? And how do you avoid a situation where an employee claims that they were working during all of those times when they were not? And so from a non-exempt perspective, remote work issues really are kind of coming to the fore, in part because of the pandemic, when we realized that we could work at home. And for exempt employees too, it's a challenge, because how do you monitor the work that people are doing? And if they come forward and they say that they were performing mostly non-exempt activities, how do you challenge that? And so all of that kind of comes to the fore. I think about all of the novel issues that plaintiffs' lawyers are raising, and pre-shift, post-shift, meal break stuff. I think about the airline industry, air carriers who are typically accepted from the FLSA. We're seeing challenges under state law claiming that flight attendants and others should be permitted to recover for missed meal breaks and pre and post-shift work. And we're even seeing challenges that some employees who are not directly related to the airlines or air carriers' primary business having claims under the FLSA. I don't think those go anywhere, but they're there. And it just shows how the plaintiffs' bar is continually looking for new avenues of attack. Speaking of that, I look at the regular rate and overtime premium calculation compliance issues. And, we actually have people on our team who love this stuff. I mean, they're kind of the A team of regular rate and overtime pay calculation issues. And it's math, and it's novel in some respects. We're seeing claims now that, so employers are constantly looking for ways to incentivize their employees to work and to reward good performance. And so we're seeing some employers provide stock grants to employees, and plaintiffs' lawyers out there now are challenging those as something that needs to be includable in the calculation of regular rate and overtime premiums, which is something that probably most employers haven't thought about. And so there are efforts by some of the plaintiffs' bar to bring things like ESPPs into the mix and ESOPs into the mix. And I'll just tell you, there are specific regulatory provisions that deal with all that. So, you can really get into the minutia of these requirements as you're looking to respond to employees' claims. And then I'll mention, yeah.
Right, this is Noah. I want to just interject with one litigation angle to the regular rate and overtime premium calculation point, which is that I'm seeing from a few firms that they're always including regular rate claims now in their collective and class litigation allegations up front. Sometimes they're well investigated, sometimes they're not. But the point of it, and they often don't involve a lot of money, but they are the lever to get to get certification. Because it's easy to show that as a nationwide common practice across all non-exempt employees, and so this is showing up in complaints all the time now. So compliance in this area really seems to be at a premium, even when the actual damages from that particular claim won't be huge.
Yeah, that's a really good point, Noah. And I think about how there are certain firms, plaintiffs' firms out there who really are searching every nook and cranny for claims that they can bring, not only in order to, these regular rate claims, the damages are relatively low because if you're missing the calculation of including an incentive payment that's relatively low in the first place in regular rate calculations, the way that you determine what needs to be included under the FLSA would be to divide all hours into that incentive payment, take halftime of that, multiply that back times the overtime hours in the period that was covered by the incentive payment, and you end up with sometimes pennies. But to Noah's point, it's a unifying factor. I think about this point number 5, guarding the outside sales exemption when employees cannot work outside. That's kind of it's a quirk that comes out of COVID, and certainly we need to be, as a sales organization, looking at the sales folks who are classified as exempt because they're going to see customers or going to their customers' places of business. During COVID, we saw a bunch of people who had to sit in their home offices and place calls, so the nature of their job changed somewhat. And that's been an area of attack by some plaintiffs' lawyers. But then you take it a step farther, and I think because of that, because the plaintiffs' bar was looking at these outside sales roles, they started considering too when outside sales folks are in training and whether they are actually engaged in sales activities while they're learning to do their job. And so that's another place that I would encourage everyone to look at. As Noah mentioned, state law issues and even local ordinances, as I suggested, are becoming more important to pay attention to. But I'll just kind of give you a quick list of the places where I see new laws coming about that really should be attended to. That's Colorado, Illinois, Maryland, Massachusetts, New Jersey, Oregon, Virginia, Washington. And that's not to say that there aren't others out there, but those are kind of the places where we're seeing new laws that are giving rise to new attacks by plaintiffs' lawyers. And I think sometimes employers don't even, it's not on their radar until they see that threatening letter come through from a plaintiff's lawyer. And then as a means to respond to that complaint, to get ready to respond to that complaint, they begin looking at the laws and realize, we've got a potential issue here that we need to remedy. And so with that, I think I've left this up on the screen enough. And I will admit that much of this is taken from my perspective of the calls that I'm getting from clients and the questions that they're asking about. So there are definitely more issues out there, but these are my top 10 right now. And I'll turn it over to Andrew to talk about California now.
So in California, we are seeing similar issues, but because we're California, there are twists on all of them. And like Brett, my list is not necessarily in any particular order, but in terms of what we're seeing over the last 10 years and the rise of different claims, these certainly are major trends that we're seeing. And the first two go together, although I'll talk a little bit about them separately, but they are, frankly, joined at the hip. The California, and here's one where we can say California doesn't get credit for inventing this. We actually adopted this. I actually think it was Maine that came up with the ABC test originally. But California, with the passage of AB 5, enacted the ABC test, and there is a very strong attack by the California legislature on the use of independent contractors. And the plaintiffs' bar has picked up on that. And obviously, the gig economy cases get a lot of attention, but it would be wrong to think that that is all that the independent contractor litigation is about. Far from it. Just about every employer is dealing with independent contractor issues. And this is where the tie-in to number 2 really comes into play, which is the joint employment claims as well. Because in addition to independent contractor litigation, we're seeing a huge increase in the number of joint employment cases being filed, and the expansion by the California Supreme Court of the definition of what is joint employment and what is the test. There's a couple of different tests. I'm not going to get into the nitty-gritty of it today, but suffice it to say that the courts are interpreting the standard to be, if you have any control, even if you don't actually exercise that control over the terms and conditions of employment, that makes you a joint employer. And so what we're seeing now is employers are getting hit with joint employment cases, easy ones, obvious examples, any temporary employees, staffing agency employees. In fact, California has a provision in the code that makes the core employer jointly and severally liable for wage claims with a staffing agency for temporary employees, provided a certain notice is given. But it's more than that. It's your regular vendors. You get hit with claims now that your vendors are not complying with wage and hour laws, and the vendors might not be a deep pocket, but you are. And so the claim is now that you're really the joint employer. This brings up, in terms of the compliance issue that Brett was talking about, a main issue out in California, which is what level of compliance or certifications, representations, and warranties are you looking for from your vendors with regard to their compliance with wage and hour laws? And by doing that, are you making it more likely that you are in fact a joint employer? And where's that balance? So for example, in California, given the expansive nature of the test, we often will tell clients that unless you're prepared to really pull out and say, hey, you just do what you do, we are contracting only for the results, and we're not interested in getting involved in any way, that often you're better off biting the bullet and saying, okay, we want certifications from our vendors that they're doing it right, that they're paying people right, that they're giving breaks correctly. We want indemnification clauses if we get sued. We want to know that you can stand behind a judgment if we get hit with it for things that you guys aren't doing right. It may be that we want the ability to periodically audit your practices, and we want to see your books, especially if you're the one paying people. And so those are all issues. This is where the litigation and the compliance issues merge together. But those two issues, which I'll sort of put down as who's your employer, who's your employee, are two huge ones that we're seeing in California. Next, as Brett was mentioning and Noah was mentioning, regular rate has gone up exponentially recently in California. As Noah mentioned, plaintiffs' lawyers love regular rate claims because they're easy to certify. And they tend to be claims that would go to most of your workforce. But California, of course, has twist. So one of those is that while Brett mentioned that the actual damages for a regular rate claim tend to be pennies in any particular instance, because it's an issue of did you properly gross up the overtime properly, did you use the base rate or the regular rate, not a lot of money there. But in California, we have a panoply of penalties, the alliteration was unintentional, that the plaintiff's bar is really looking at. So for example, we have penalties if you didn't pay employees correctly upon termination of employment. Call them Labor Code 203 penalties. And those penalties, literally, you could owe somebody a dime of unpaid wages. And let's say it's the person's making $30 an hour. You could be on the hook then for 30 days of wages, which basically would get you penalties of $7,200. You start multiplying that out by the size of your workforce and the number of terminated employees, those numbers go up fast. And of course, there's attorney's fees, and let's not kid ourselves, plaintiff's bar is really filing these because of the attorney's fees. But in addition to that, the regular rate of pay claims in California have yet another twist. So recently, there have been a number of decisions out of our lovely Supreme Court and Court of Appeals that not only is the overtime required to be paid at the regular rate of pay, but the meal and rest premiums have to be paid at the regular rate of pay, as do sick payments. So these are a lot of places that employers they may not be aware of it. It's an easy gotcha for plaintiff's bar. And let's be honest, regular rate of pay is complicated, it's tricky, it's easy to get wrong. There are lots of HR folk who don't understand it. There are a lot of payroll people who don't fully understand it. And so, as Noah was mentioning, plaintiffs' lawyers love these claims because they go in with the assumption that if they can start doing discovery, they'll find something. Unfortunately, often they're correct, which gets back to Brett's point about the importance of compliance and making sure you do your own internal audit. A couple of other things that we've seen the rise of, and I'm not going to talk about each one of the items on the list. In California, the de minimis doctrine, the de minimis defense, is on its last legs. It isn't officially dead, it's just mostly dead, for those of you who like The Princess Bride. And so what we're seeing with that is that's leading to the off-the-clock claims tend to be very difficult to certify, but the elimination of de minimis has given life to the off-the-clock claims again. Same thing with regard to rounding in California. The California Supreme Court has already strongly implied that it is going to eliminate rounding. The California Courts of Appeal have pretty much said there is no reason for rounding, and that issue is pending before the California Supreme Court right now. We expect that by next year, rounding will be no more in the state of California. Anybody who is rounding in the state of California, now's your time. Stop it. Because what we've seen out of the California Supreme Court is that when they announce these changes that we all think is a change of law, The California Supreme Court says, no, that's actually not really a change in law. You just didn't ask us before. And so all we're doing is announcing the law, not changing it. And the importance of that is it becomes retroactive. And so for those of you who are still using rounding in the state of California, really should consider getting rid of it. Other things that we're seeing, as Brett mentioned, remote work has brought a whole panoply of new claims in California. Not only are we seeing a host of new off-the-clock claims, but we're seeing expense reimbursement claims. In California, you're required, unlike many states, although California is not unique in this, you're required to reimburse employees for expenses, and you can't, unlike under the FLSA, use the base rate of pay to cover expense reimbursements. You have to reimburse separately. And so in a little bit we'll talk about some of the novel theories that we're seeing out of the plaintiff's bar with regard to this, but it used to be that we never saw or rarely saw these expense reimbursement claims because they weren't really suitable for class action type litigation, because it was a one-off. Joe went to a trip and you forgot to reimburse him. Now with the remote work and work from home, we're seeing these claims every day with, for example, things like home internet or use of cell phones. And again, the biggest one, and this will come as no surprise to anybody who is in California, is the exponential rise in PAGA claims over the last few years. There's a number of reasons for this. The first is, as employers started using class action, arbitration agreements with class action waivers, Plaintiffs' counsel looked around and said, wow, that's a huge threat to our existence. What are we going to do about that? And they latched on to the Private Attorney General Act claims. We rarely saw these 10 years ago. They are the flavor of the year, the decade to come, you name it. Because the Private Attorney General Act claims, it gets complicated, but the short version is a waiver in an arbitration agreement doesn't really work. There's a lot of nuance to that. We're going to talk about that in a little bit. It's the interplay of the Viking River decision from the U.S. Supreme Court and the Adolph decision out of the California Supreme Court. But the short version is that the representative portion of a PAGA claim is still alive. And one of the reasons that the plaintiff's bar loves it is that, unlike a class action, you don't have to deal with the Rule 23 type of certification standards. There is no similarly situated, there's no commonality, predominance, none of those things apply, because PAGA is a representative action. And so what we're seeing out of the plaintiff's bar is that they're filing these and they're alleging them as to all non-exempts. And in terms of the standing issue, and we don't have time to talk in great detail about PAGA in this, that'll have to wait for another day, but the standing requirement as interpreted by the California Supreme Court is so low, it is essentially you were an employee and you suffered any violation of the labor code, and that allows you to bring a claim for the violation of every portion of the labor code as to any employee in the company, even if you were never affected. plaintiffs, that is a gold mine for plaintiffs' lawyers. And so that is easily my number one pick for the top development over the last 10 years in California. And I will turn it back over to, I believe, Noah.
You know, I'll step in real fast. In the last 15 minutes that we have, we're going to just run quickly through some other developments and then turn to what is next and what's on the horizon. So if you go to the next slide, please. No, I know that this first bullet is one of your favorites to talk about. Do you want to say just a few words about the deference issue?
Yeah, I'll go through it really quickly. Point here is that, there's the Department of Labor is not important in the wage hour world as it used to be. First of all, we're seeing significant questions in litigation over the Department of Labor's authority to raise the minimum salary to be exempt. It's going to be trying to do that soon, or to even maintain a minimum salary for exemptions, period, and also about the tip credit rules. We're also seeing doubts about the continued viability of Chevron deference to various DOL regulations, and many courts these days have been refusing to defer to DOL interpretations, even under the Skidmore doctrine. And meanwhile, what's been also interesting from a compliance standpoint is that the Department of Labor hasn't even been providing the guidance that it used to. We used to see opinion letters from the Department of Labor all the time. That was a major source of what we used to advise all our clients on these issues. And in fact, in the 10 years before we published our book, there were an average of 20 opinion letters per year. And in 2005, there were actually 54 of them. But in the last 10 years since publication, we've only seen 5 per year on average. So it's really dropping off.
Yep. And so I'll just kind of keep things rolling. The Wage and Hour Division's investigators, some of you may have seen the media reports that they've got an attrition issue. They keep on losing investigators, even as they're getting more money to add new investigators. But we're seeing varying levels of aggression by the investigators. Some of them insist on liquidated damages. Some of them don't. Some of them insist that a response be provided within a very short order to any of the requests that they make. We're seeing interloping state and local agencies with the attorneys general bringing claims under those states' laws. I think that to an extent, some of the states have kind of stepped in where they foresee that the federal government's not going to. This point about uncertainties about what's necessary to prove good faith compliance. There have been a couple cases recently that have said that an employer cannot prove that it did not willfully violate the law, the FLSA, and did not act in good faith if it didn't have an attorney provide counsel on the practices that are at issue. And that's a stark difference from what we saw decades past, when just having a lawyer involved would be enough. But nowadays, courts are really picking up on that. We're seeing ebbs and flows in a connected way in the internal exemption and pay practice assessments that our clients are doing. And we're seeing threats by the federal Congress to make changes to the FLSA to make it a more arduous and more strict law to comply with. We probably won't see that come down the pike, but they're trying. Noah, you want to take the next?
Absolutely. So what do we see happening now in the next 10 years? So if we can go to another slide or two. We'll note that making predictions is a hazardous business, and particularly when there's political developments that affect a lot of them. But we're going to do it anyway. We polled a lot of our colleagues in trying to come up with this, and there were a few interesting insights. One of them, the one thing I think we can be sure we're going to get, is that employers are going to continue to adopt or maintain their arbitration agreements with class waivers. And as that happens, there's going to be more and more fights over them. We certainly think we'll see more of that mass arbitration phenomenon that I talked about. And we also think that more states are going to adopt their own PAGAs that Andrew talked about. There have been some proposed in several legislatures, and those in our Seattle office have told us that we should probably expect Washington State to have its own PAGA later this year. Whether it'll be effective this year remains to be seen, but it's coming. Beyond that, we don't expect any about-face from the Supreme Court on the arbitration issue, but we do think that if Democrats keep control control of the White House and the Senate and take the House in the upcoming election, there's a very good chance of federal legislation that will ban mandatory arbitration. That's already happened on harassment claims, and we think it could happen more broadly to include arbitration of wage hour disputes as well, and also consumer disputes. That, of course, is just entirely dependent on politics. So, take that with a grain of salt. We just don't know how those elections are going to go. Now, if that happens, if by federal legislation arbitration does go away, we'll need to look for other avenues of class or collective action avoidance. One of those could be what I call reverse forum selection clauses. This is where an employer and employee agree, likely in onboarding documents and as a condition of employment, that the only location in which disputes between the two of them, that being the employer and the employee, can be resolved is the judicial district in which the plaintiff employee works. That, if upheld by courts, and we think it would be because forum selection clauses are routinely upheld, that can prevent a nationwide collective action or sometimes a statewide class action. Of course, if an employer has a large concentration of employees in one judicial district, that may not help much, but it will confine litigation to those various districts, which will reduce the impact of class and collective litigation if arbitration agreements are no longer an effective way to avoid collective and class actions. We also think that at the federal level, that we're likely to see the recent decisions out of the Fifth and Sixth Circuits on collective action standards to have resonance, and that many other circuits are going to realize they've been too lenient in first stage collective action certifications and need to tighten up the standard a little bit. We think those decisions are persuasive. They're actually, when you look at the authorities of it, there's not a lot of appellate authority on it. Really, the lenient standard is made up of a mass of decisions at the district court level, with the appellate guidance being somewhat sparse, and therefore making those Fifth and Sixth Circuit decisions particularly important on a go-forward basis. Despite that, good news, we expect some bad news too. We think the blue states, and those typically are the ones that allow wage hour claims to be brought on an opt-out class action basis, are going to enact even more draconian penalties against companies, and that companies are going to face more high exposure wage hour class actions on the East Coast, West Coast, and in the Rust Belt. And we also think that the de minimis defense is going to go away at the federal level, pretty much as it kind of has in California as well.
So if you go to the next slide, we'll just run quickly through some of the compliance issues. I mean, really, the past predicts the future in this circumstance, and a lot of the claims that we've seen, a lot of the compliance issues that we've already discussed are going to give rise to what we see in the future. Expanding definitions of employment, what it means to do work when someone is an employee. We've heard discussions about a third rail of employment, somewhere between employee and an independent contractor coming down the road. Not positive that it will land there, but maybe. We will likely see a pretty significant increase to the salary level requirement under the 541 executive, administrative, and professional exemption under federal law. States are already bumping up pretty high on that requirement, so pay attention to that. We'll see, and we've talked about a demise of rounding, but I also would highlight the Portal to Portal Act is somewhat under attack in the states. Pennsylvania, man, that's a challenging place to be these days. There are some plaintiff shops who are really attacking on all grounds, but there's a question of whether under state law, some of the activities that occurred pre-shift and post-shift can be excluded from the definition of time worked now. And we think we'll also see some change in the way that the administrative exemption and outside sales exemption can be applied because of the changing nature of work that employees are performing. So you'll see these. You can look at this list when you get the materials and follow up, but those are the top 10 or some of the top developments that we see coming down the road in compliance. Andrew, California?
So the story in California is more of the same. We are going to continue to see an avalanche of PAGA claims. Now, and I've mentioned before the recent Adolf Uber decision out of the California Supreme Court that has changed the landscape. So for employers that have arbitration agreements that has a representative action waiver in it, what we're now looking at is a bifurcated procedure where the individual PAGA claims, which really is a bit of a misnomer, they're the claims that arise out of the individual private attorney general plaintiff's employment. Those are going to go to arbitration. The representative claims as to all of your other employees are going to remain in court but be stayed pending the resolution of the arbitration. If you win the arbitration, then that divests the plaintiff of standing, and you can move to dismiss the representative claim. But if you don't prevail in the individual arbitration, you're going to be right back in court. And so the landscape has changed, but the threat remains. But we're also going to be seeing and we're already seeing a tremendous number of battles over the scope of discovery. One of the reasons that plaintiffs love PAGA claims is the expansive nature of discovery. Basically, if I have just a little in, it allows me to go in and tell the court that I get to audit you for all of your wage and hour practices. And there are courts that are buying that. And so we have a number of defenses about with regard to that. We've been quite successful in a number of cases of limiting it, but we're going to be seeing a lot of battles about that, and we're expecting quite a number of Court of Appeal decisions about the proper scope of discovery in PAGA cases. Similarly, sort of a cutting edge issue right now is getting PAGA cases dismissed because they're unmanageable because of the scope. Similar to if you were dealing in a Rule 23 or collective action situation, a motion to decertify. Again, we've been successful to date with those arguments, but that issue is now pending before the California Supreme Court, and my crystal ball is just not clear enough to be able to tell you what the California Supreme Court's going to do, because it's the California Supreme Court, and I'm not sure I trust them on anything. Another issue that, and this is a little interesting for California, Brett was mentioning the continuous workday rule. We don't actually have that in California at the moment, but we expect that that's going to be adopted. And as Brett was mentioning, the application of the continuous workday rule in the context of remote work is going to be very appealing to the plaintiff's bar in terms of additional lawsuits. So remote work is going to lead to a whole host of new claims and continued litigation. A number of these we've already talked about, and so I'm not going to go back over again. One other, though, that I do want to highlight is the rise of predictive scheduling laws in California. We're seeing a lot of municipalities enacting them. We expect on a state level, we're going to be seeing a lot more action in that regard. And so in retail and in hospitality, this is going to be a pretty big issue in the coming years. Next slide. For those who have been waiting for the CLE code, I will announce it for you. It is SS, as in Seyfarth Shaw, 6421. Again, SS 6421. And with that, want to give you quick coming attractions for the rest of the series here. Today was just intended as the overview of where we've been, where we think we're going. We have a continuing webinar series where we're going to dive deep into some of the issues that we're seeing. You can see what we've got on the agenda coming up. The first one will be starting, we're going to give everybody August off for summer break, but we'll expect to be starting up in September with the first one. They will be 30-minute ones, so they'll be smaller, more bite size. We encourage everybody to join us. We'll be sending out invitations to them, so that'll have the actual dates on them. And for those who don't already have a copy of the ALM treatise, on the next slide, there is a link where you can purchase the book. It will also be in the materials. There will be information in the materials if you want to acquire it. Or, of course, you can just reach out to your favorite Seyfarth attorney to order a copy. And it is both in hard copy, or there's an electronic version if you don't want the 1,000-page book sitting on your bookshelf, although it is a lovely addition to your bookshelf, and I encourage everyone to have it. With that, given that we are at the top of the hour, on behalf of myself, Noah, and Brett, we thank everybody for staying with us. We hope that this was informative for people as we sort of took our little retrospective look back over the last 10 years and our prospective look at where we think things are going in wage and hour, both nationally and in California. And again, if you have any questions, feel free to reach out to myself, Noah, Brett, or any other member of our practice group. And thank you again for joining us.